Colleagues, just before the March break, ETFO uncovered some disturbing information, which was reported to you in a Bill 115 remedy update on March the 10th. During settlement discussions, ETFO was repeatedly told by the Liberal government that it had no more money available to fairly compensate ETFO members for the significant losses they incurred under Bill 115. At the same time, it was telling us it could not offer our members more than a fraction of what they lost. ETFO found out the government had also been involved in secret talks with unions that were not part of our charter challenge. You may have seen in the news that the Liberal government recently and very quietly agreed to pay the Catholic Teachers Union, OECTA, $31 million. The cover story given to the media is that this payout is related to a local grievance filed by OECTA about salary grid movement during the 2014-15 school year. But that story doesn't hold up under scrutiny. The government isn't a party in local grievances filed by teacher unions, and it doesn't pay financial compensation when teacher unions win local grievances. Also, the government is providing similar payouts to other organizations that haven't won grievances. For example, another teacher union, AFO, filed a similar local grievance and lost. That union is also receiving a payout from the government. When you examine the facts closely, the deals made by the Liberal government with unions that were not part of the Charter Challenge are, without a doubt, poorly disguised Bill 115 settlements. Why are these payouts a problem? First, it means Kathleen Wynne's government very likely offered ETFO members an inferior Bill 115 remedy settlement so it could provide tens of millions of dollars in payouts to education sector unions that supported the Liberals' austerity agenda in 2012. The second problem goes beyond the Bill 115 remedy settlement and raises serious concerns about the Liberal government's conduct during ETFO's 2014 round of central bargaining. Collective bargaining is a process that requires everyone at the table to negotiate in good faith. In Ontario, all parties have a legal duty under the Labour Relations Act to be honest and transparent about their intentions, and provide complete information, and be truthful in their statements when they are bargaining agreements. Withholding information that one party needs to accurately assess a proposal or deliberately misleading the other party violates that duty. During the 2014 round of central bargaining, the government insisted that no deal could be reached with ETFO unless grievances we had filed about the 97-day delay in salary grid movement during the 2014-15 school year were considered resolved. ETFO signed the 2014-17 Central Agreement based on the understanding that all teacher unions had agreed that the delay in grid movement would end in September 2015. ETFO would not have resolved its salary grid grievances on any other basis. We now know that the Liberal government has provided money to unions that were not part of the Charter Challenge and will not reach a fair Bill 115 remedy with ETFO, a union that sought to protect the charter rights of its members in court. In ETFO's view, this action and the government's conduct around grid movement during the 2014 round of bargaining is contrary to the government's legal obligation to not act in a discriminatory manner and to bargain in good faith. Your provincial executive cannot allow the Liberal government's actions to go unchallenged. As a result, today ETFO is filing an unfair labour practice complaint with the Ontario Labour Relations Board against the government. And links to ETFO's unfair labour practice complaint and explanatory notes are included in this e-newsletter for members to review. ETFO is also considering other legal options in response to the government's deceptive and unethical behavior. You have my assurances that ETFO members, that you will be kept informed as these options are implemented.